please the court, John Turner for Lee County. This is an appeal in an eminent domain action involving a transportation corridor for a particular area called Burnt Store Road. The issue on appeal that we're addressing has to do with an order entered by the trial court on the property owners, the Weidner Corporation's motion in limine that was entered after the order of taking had been entered, after the declaration of taking, after the money had been paid in. And the motion...
the money was paid in on a quick take, right?
I beg your pardon?
This was a quick take?
Yes, Chapter 74. It was for a roadway project. I think that's pretty clear in the record. The issue, though, is not as simple just as it appears because of what the property owner was complaining of. And the property owner was basically saying this: I bought the property in 2000. I'm holding it for investment purposes. I'm not going to build anything on it, which is fine. A lot of people do that in Florida, particularly in Lee County. And the county came in and indicated that they were going to build some road improvements out here on this road, which I own the property on, called Burnt Store Road. And the county issued some public notices of what they were going to do. And the first thing in the record occurred in 2003 when the county, through its county lands or real estate department, sent out some letters saying, hey, we're thinking about buying some property out here for a road project, and if you're interested, we'd like to talk to you about it, strictly voluntarily. We have some money available, and if you're interested, we'd like to talk to you. After that came a bi-county corridor study, and this was a study that was published by and prepared by a consultant for Lee County, Post Buckley.
And this information is all in the record?
Yes.
Okay.
And it contained a pretty thorough explanation of what this corridor was going to be. It was going to run from I-75 to the west through the Lee County, down Colonial Boulevard, into Fort Myers, over the Midpoint Bridge, through Cape Coral on Veterans Parkway, and then kind of jogs to the north and goes up Charlotte County, and then from Charlotte County back to I-75, about 35 miles in length. And the part that's the northern part is the Burnt Store Road part, and it was only a 2-lane road, and it had planned to have been improved since at least 2003. Okay.
The plan was to build a larger than 2-lane road through this, because this is like way west in Cape Coral, right?
Yes. They were going to expand Burnt Store. They just didn't know.
I actually represented the city of Cape Coral. I have a sense of the map. This was no man's land
That's
years ago.
Pretty vacant, but there's some development out there, and there's houses, of course.
They're going to build like an interstate bypass through that area? Is that what this is?
Not to that extent. There were various plans, and I guess what eventually happened that concerned the Weidner Corporation, I'll call them, or the property owner, was that there was a public notice issue, and they sent out by the Lee County DOT to all the property owners in the Burnt Store area and said, we're going to have a meeting, and we invite you to come to this meeting because at this meeting we're going to show you what we're going to do, or what our plans are, and what our preliminary plans are. And in this notice contains some language about a generalized location of where the road was going to be, and to a certain extent a definition as to how much property was going to be needed for the expanded roadway. And I'm not disputing that the language contained in the public notice says that we have a 200-foot right-of-way, but we're going to have to add on to the right-of-way for 135 feet. Now, from our point of view, when arguing this appeal, is that this was strictly a planning document, that this is a part of what governments do in roadway planning. They'll set forth an idea or concept or plan, put it out to the public, and get their input. And this is exactly what happened at this public meeting, is that they had a lot of the neighbors, it was all signed up, people, they were there, they were asking questions, and they were giving the information.
Mr. Turner, this is interesting, but don't you just have a huge problem with the fact you don't have a transcript?
A huge problem with what, Judge?
You don't have a transcript of the hearing.
No, sir, we don't.
And you don't,
No.
and you don't have any stipulation as to what went on at the hearing.
No.
So, we could dream up worst case scenarios of what witnesses said at this hearing.
If you could bear with me, make my argument, and I can't argue the fact that no, there was no transcript, and I don't know why that was the case, but we do not have a transcript of that hearing. But we do have the judge's order that he signed and issued, and that's what we have the dispute with, because he says in there, the judge says, I find there was a taking because of this public announcement. And based upon what the announcement said, and based upon what the testimony at this evidentiary hearing at the motion in limine conducted by the court, which the property representative of the property owner and his real estate agent said that he couldn't market the property after this public notice came out. So the judge is saying, in essence, there was a taking, and he uses the word taking, as a result of them not being able to market their property. So what the judge...
When this notice went out, I'm sort of concerned. Is it just some sort of generalized notice, or does it identify parcels which are subject to your planning?
The position on appeal we're presenting to the court is that for there to be a condemnation blight is what, that's my next point, is what the trial court was saying, was that there's kind of a combination of a condemnation blight and a taking. And therefore, as a result, I'm going to change the date of value back to that time when they issued the public notice, county. So you're on the hook for that, for what you said and what the value is going to be in 2005, not 2010, when you went to court to get the order of taking. So,
but maybe the case law uses taking, but you're taking the land on a given date. The problem is that the actions of the government for a period of time before that have affected the value or the marketability of the land, and that affects the date you use to value the land for the taking on a subsequent date, right?
correct.
So I don't know whether you think of that as a temporary taking, but I mean, there's no question of what day you intend to take the land. It's what day you use for valuation, depending upon the conduct of the circumstance.
Depending on what conduct is involved, and that's our whole point, is that the conduct was not to the extent that it identified specifically this property, and it did not have the approval of the Board of County Commissioner. In other words, there was no map of reservation filed by the Board of County Commissioners.
The map of reservation cases, when we were actually recognizing the map itself as a taking, that was compensable, even if the government never came and took your land, that anybody that was inside the map got compensation.
That was the joint ventures
Right.
case.
And eventually the Supreme Court backed away from that.
They did back away in the right case and said, wait a minute, and if you're going to use it for basically a planning tool or for the future,
That
then...
wouldn't mean necessarily that a map of reservation or something like that might not alter the date of valuation in an Article 10, Section 6 takings case. Because the map of reservations were all due process takings.
That's the argument. That's what we have to decide today, or in this case, one of the issues is this the type of activity that a county is going, or a government entity, a local government is going to be held as affecting the values, and whether it's the value was affected by this acquisition or the activity, or whether it was affected by something else, like in this case is the significant decline in economic prosperity of the entire country. Yeah, there was this significant, of course, the most serious economic downturn since the Great Depression occurred, and at the same time that this was starting to develop. So that's an issue that we had to bring to the court anyway. But the point is, there's not a lot of cases on this particular issue. The only case really on a planning note is the Auerbach decision from the 3rd DCA, and in which FDOT was sued in inverse condemnation by the property owner. Now, granted, this is not an inverse claim, and the property owner has not made an inverse claim. That might be something that we submit that he should have to do, or it should have to do in a particular claim such as this. But Auerbach, the 3rd DCA said, hey, wait a minute. What FDOT was involved in are planning activities. It's planning, but the court didn't outline what those planning activities were. But I think you can assume that they were probably analogous to what was going on by Lee County, and that there was public announcement that there were plans prepared, that there were demonstrations or programs held for the public, normally what FDOT or what any DOT department does. And the 3rd DCA said, no, that's not going to be a taking, because that's what's expected. That's what's necessary for this type of a project. And if the property is not identified for a taking, identified specifically for condemnation, then they're not going to have the condemnation blight. Not going to be subject to an inverse condemnation. And I think that same argument can be made in this particular case for not considering this as a quasi-condemnation blight case, is what the trial court did say, in essence, in this order. And less like all we have is the order at this time. I'm going to reserve the balance of my time for rebuttal. Thank you.
All right. Mr. Donald?
Good morning, Your Honors. I'm Robert Donald from Fort Myers, and I'm here on behalf of the landowner in this eminent domain appeal. There's some preservation issues, as Judge Altenburn alluded to. There's actually 2 of them, but the first one is the major problem that there's not a transcript of the motion in limine hearing that occurred a year and a half before trial that resulted in the order that the county is now appealing. The county makes a lot of arguments here, but they all center on the date chosen by the trial judge as a result of this hearing that was noticed as an evidentiary hearing. Evidence was taken at the hearing, as a clerk's minutes note, and the trial court made reference to the evidence taken at the hearing in its order. Mr. Turner and I both have plausible deniability here because neither one of us was there. The attorney that represented the landowner is no longer in the case, and his predecessor, I don't believe, works at the county attorney's office anymore. So we will have to remain ignorant of what occurred at that hearing in the way of evidence, and also in the way of any arguments that the county made or did not make. Here, the landowner filed a motion in limine alleging condemnation blight. The county filed no response. The landowner filed a memorandum of law. The county filed nothing, and we have no transcript of the hearing. So for all we know, the county showed up at the hearing. We know this didn't happen, but the county could have showed up at the hearing, and they could all put their arms around each other and say, yeah, we all agree that this is the date. That didn't happen, we know. But we don't know what happened at that hearing, and sort of a basic rule of appellate review is you can't attack a factual finding without having a transcript. We can talk about Applegate and Esau, and I won't bore you with the cases that you guys read 1,000 times. But in Esau, then Judge Canday said the most salient impediment to appellate review is the failure to have a transcript. Judge LaRose, you said in the Source Track case of 2007, dealing specifically with a motion in limine, absent a transcript of the hearing on the motion in limine, we must affirm a ruling that is not fundamentally erroneous on its face. So this is the first foundational problem, but there's a second one, and that is The county never proffered any evidence as to what the valuation would be at some alternative date that it thought to be more appropriate. Recall here that the landowner at trial advocated a $108,000 value. The jury found the value to be, as the county stated, at $68,000. That's a $40,000 diminution in what the landowner was asking for. We don't know that the value would have been any less at any other point. The county has not provided anything to show that. There's section 59.41 of the Florida statutes that requires the appellant to show some harmful error. Again, then Judge Kennedy said in the Marshall case, you've got to comply with the statute. He repeated the same thing in Esau and said you've got to proffer some evidence to show that there would be harm by virtue of the ruling you're attacking on appeal. As I think I've already said.
Does it make any difference that it's almost public knowledge that between these two dates that the valuations in Florida, and particularly in that area, went way down? I mean,
are you talking about judicial notice or something?
I mean,
well, actually,
the 4,000 foreclosures that have come through here from Corey.
You'd all have to be deaf, dumb, and blind not to know that. But also here, actually, it's a little bit more complicated than that. Because one reason, or it seems like the only reason that the jury went with the county's valuation is because it had to find there was no reasonable likelihood that this property could be devoted to a commercial use. That scenario in 2006, the valuation date chosen by the trial court, might well have been different in 2010 when the deposit was paid. So it's an issue that could actually break both ways. In a way, it might have benefited the landowner to have a 2010 date on this commercial use issue, but we'll never know that. I think I've made the point that we really don't even know what the county argued below. We've got no way of knowing that. No papers, we've got no transcript. But all of its 5 points on appeal center around this finding as to the valuation date. But the way the county presents its points actually emphasizes the weakness of its arguments. Its first point is that the evidence does not support the trial court's finding as to the valuation date. And then it cites evidence taken at the trial a year and a half after the motion in limine hearing, and at the trial where the valuation date was not an issue, to try to support its argument. I mean, that inherently doesn't work. The issue is the evidence taken at the motion in limine hearing, not what happened at trial when that was not even an issue, okay? Secondly, I got to disagree a little bit with what Mr. Turner says. He wants to boulderize or lessen in probative force the evidence given to the public back in December of 2006, the valuation date chosen by the trial court. Up until that time, there had never been any definite statement by the county as to what it intended to take, and that it had funds to take that. At that point, the idea was that Burnt Store Road was going to be converted into a 4-lane road. There was a 200-foot right-of-way there already, and the existing 2-lane road was on the far western side of that, taking up less than half of the right-of-way. So if it had been made into a 4-lane road, there likely wouldn't have been any need for property at all. The county then revised its plans to take an additional 155 feet on the eastern side of the right-of-way, which includes all of my client's property. Okay. On December 6th, it announced, and by request for admissions, the county admits that it disseminated this information to the general public, that it was going to take the property, and it had funds to pay for the property. So it was beyond speculation. We've got the money to pay for it. We're going to take it. went on to say, we don't necessarily have money to build the road, but we got money to take the property, we're going to take the property. Okay, so as of December 6, 2006, there's no issue that the county is going to take the property, and the property it's going to take is going to include my client's property. That's why the trial judge chose that date. Let me read briefly from the Ciccone case, which is sort of a landmark eminent domain case here in Florida from the Supreme Court in '63. And Justice O'Connell, those of us who remember him, said, once selected for condemnation, the marketability, both sale and rental, and to some extent the use of property is sterilized, and its value either as determined by market value or use by the owner is decreased. The only thing that an owner, once the government says it's going to take the property, nobody's going to buy the property. You're buying a lawsuit in essence. The only thing that you maintain the right to do is pay taxes on the property. Remember, there was over a 3-year wait between the time the county announced that it was going to take this specific property that had money to take it and the time it actually took the property. So yeah, bad things happened in that 3 years. But whose fault is that? That's the county's fault for announcing without any kind of reservation that it was going to take this property. And indeed it did take the property. It just waited 3 years. The fifth point the county raises is says there's no evidence of condemnation blight. And again, we're to an evidentiary issue, and we don't have a transcript of the hearing where this issue was determined. So it's got that problem to begin with. But this seems to fall squarely within the concept of condemnation blight. And that's where the government says, we're going to take it, this is the property we're going to take, and we got money to do it. I mean, that's a definite situation, and when that occurs, I would advocate that at this hearing, the witnesses probably said that when that occurred, the value of this property essentially was frozen in time, and nothing could be done with the property until the county actually took it, which it did 3 years and change later. The county raises several other points that I don't think Mr. Turner has really spoken of here, so I probably won't either. I would mention one thing to add to the definiteness of what the county said in December of 2006. They filed their right-of-way plan or map or whatever those things are in February of 2007, only 2 months later, having a map showing this property, okay? So, I mean, there's no doubt that in December of 2006, the date chosen by the trial court, things were sort of frozen in time, and the trial court realized this and realized that it wouldn't be fair to use a valuation date some 3.5 years later that bore no relation to when the county froze the property in time, exercised its right to take the property involuntarily from the landowner. And therefore the Constitution required that that be the date valuation should be determined at, because valuation is in the final analysis a judicial function, and that was right for the trial court to do. Thank you, Honors. I ask that you affirm in all respects.
If I can sit down, you have a motion for fees that's based on condemnation?
Yes, sir.
Okay.
I'm going to read from the public notice that was sent to all the property owners in which the trial court relied on finding taking. And this is the part that I believe that the trial court was referring to, which he does in his order, that currently the existing right-of-way along Burnt Store Road is 200 feet. An additional 155 feet is required along the east side of the existing Burnt Store Road for the new design. Although funding is not currently available for the construction of the project, right-of-way funding from surplus tolls is available to acquire properties over the next 5 years. Construction of the new Burnt Store, and then goes on to explain that it was adopted by the Lee County Metropolitan Planning Organization, which is not a Lee County division or department. It's a separate planning division of private individuals, basically, companies. And another concept in the eminent domain area field is that a right-of-way map or a planning map or even construction plans that are not introduced into evidence in a taking setting, such as in a Chapter 74 quick take setting, and they aren't being relied on by anyone, can be mended, they can be changed, alignments can be changed, and in this particular case, the evidence was that these right-of-way maps, or this map at the time, which included the Wyman property, was a preliminary right-of-way map. And so I submit that these things are subject to change. They are changed frequently in construction projects. And it's not something that specifically identifies. It's not the Board of County Commissioners passing a resolution of necessity saying, yes, we need this property, this parcel, and the Wyman, we're taking it. It's totally different from that. It's a preliminary planning tool. Ask the court to take that into consideration. Regarding the value, the evidence, the record is clear that the value of the date of taking from the good faith estimate and appraisal by Lee County is in the record, and is also in the record the evidence of the appraisal by the county's appraiser that supported that opinion. So it's not like this is a big surprise as to what the value was in 2010 as compared to what it was in 2006. So thank you for your attention. I appreciate it.
Thank you. That concludes our document. It's adjourned. But does anybody know whether there was a burnt store on Burnt Store Road?
It's in, yeah, I do actually. It's burned down.
Yes, that's right.
But it's in Charlotte County.
It's
It's,
up,
that
that
area is
road goes
actually-
way, well, there's an old Burnt Road. This is a different road. This is a different road.
but Charlotte County and Lee are growing together at way out there is what's sort of happening here.
Yeah. All right, thanks.
All right.
I guess I can go on vacation then. Good to see you.
I'll leave on Friday, so.
No good. Enjoy your vacation. Got some more burnt store cases to file.
Sick of burnt store.
I bet you're a lot sicker of it than I am.
Remember the day I heard that name?
Well, actually, a lot of cases, not a lot, but most out there are from properties that